You're listening to Systemic Error Podcast. The failure was designed.
The bad news buried in the Supreme Court's birthright citizenship ruling, based on an article by Robert Rye. The court said no, the damage was the point, power, not confusion. The immediate fact is simple. The Supreme Court blocked Trump's attempt to erase birthright citizenship with a Day 1 executive order. The order would have stripped citizenship from children born in the United States if their parents were undocumented or on temporary visas. Lower courts had already stopped it because it plainly collided with the 14th Amendment. That is the legal record. The political record is harsher. Trump used the presidency to test how far he could push a direct attack on a constitutional guarantee, then forced the country to spend months litigating whether a president can just announce away citizenship. Who drove it? This was not a bureaucratic misunderstanding or a legal gray area. Trump made birthright citizenship a political project years ago, and he brought it to the White House as an executive order on Day 1. His Solicitor General defended it at the court. The administration's theory was that the 14th Amendment should be read narrowly, as if a century of settled understanding were just an inconvenient accident. That is where responsibility sits, with the president who signed the order and the legal apparatus that tried to launder it into a serious argument. The issue was not confusion. It was a deliberate attempt to convert executive power into a weapon against a category of children. The frame was the trick. The language about birth tourism is doing the usual ideological work. It takes a constitutional right and recasts it as a loophole exploited by outsiders. That framing tries to make exclusion sound like housekeeping. It is not housekeeping. It is an attempt to create a hierarchy of belonging by administrative decree. The article correctly notes that the lower courts unanimously rejected the order and that no serious constitutional lawyer expected otherwise. That matters because it shows how thin the administration's case really was. The point was never strength of argument. The point was pressure, spectacle, and the normalization of saying that some U.S.-born children should not count. The court's narrow escape. Chief Justice John Roberts wrote for the majority that citizenship is a constitutional promise extended to the freeborn in this land. That should have been the end of the story. The fact that it was not unanimous is the disturbing part. A 5-4 result on something this basic means the court is still one vote away from blessing a grotesque reinterpretation of the Constitution. Thomas, Gorsuch, and Alito dissented, and Thomas offered the sort of historically selective nonsense that always arrives wrapped in the language of original meaning. Kavanaugh agreed the order was unlawful but wanted the court to dodge the constitutional question. That split is not an academic footnote. It is evidence of a judiciary where the hard right remains eager to ratify executive cruelty if given the chance. What this was really about. If Trump had won, the consequences would have spread far beyond the named policy. The source is right to flag the panic such a ruling could have triggered among immigrants and their families. More importantly, once a president succeeds in redefining citizenship by fiat, the next administration inherits a more permissive battlefield. What starts as an order aimed at future births can become a template for retrospective stripping, status uncertainty, and state-managed fear. That is the deeper pattern. Authoritarian politics often begins by targeting a right so basic that the outrage is supposed to be self-correcting. If the system hesitates, the damage is already done. The message is sent. The boundary is tested. The public is trained to treat citizenship itself as conditional. The larger lesson. This case was not about one reckless order. It was about the recurring strategy of converting nativist resentment into constitutional experimentation, then relying on institutional caution to make the experiment look respectable. Trump supplied the provocation. His lawyers supplied the gloss. The court, this time, refused the bait. But the narrow vote is the warning. A legal system that has to scrape by 5-4 to preserve a right written into the Constitution in plain English is not in healthy shape. It is one vacancy away from surrendering a core democratic promise to a politics of exclusion. You've been listening to Systemic Error. Thanks to Alternet for today's article, with the automated voice of Amy. Thanks for listening.